1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်1356 Union of Burma Plaintiff vs ဦးတင်A Defendant ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before ဦးကျော်စံဦး Judge Union of Burma Plaintiff vs ဦးတင် A Defendant Suit for recovery of money being the value of best of groundness, no agreement or evidence of uses of trade to justify the award of interest, whether the provisions of the Interest Act are applicable, whether interest is payable under Section 61 of the Sales of Goods Act. Hell, there is neither agreement nor evidence of uses of trade to justify the award of interest. As a matter of fact, mercantile usage to pay interest in a case of this nature was not specifically pleaded. Under the provisions of the Interest Act, the Code might allow interest where time was fixed for payment or where no time was fixed from the date on which the demand of payment was made in writing, giving notice to the debtor that interest would be claimed, but no time was fixed for payment of the debt, nor is there anything to show that a claim for payment of interest was made in the legal notice. Interest is not payable also under Section 61 of the Sales of Goods Act. Therefore, the claim for interest from the date of last part payment to date of suit is untenable in law. Domya Tanu, Government Advocate for the Plaintiff, Mr. G.N. Banerjee for the Defendant, Ujo San-u, Judge. This is a suit for the recovery of debt 57,257.98 yeah, being the values of the balance 633 best of groundness, debt 20,030 yeah, with interest at 9% per annum from February 1962, which was the last time the part payment was made to the date of suit, viz. 4 December 1964, debt 4,950, the balance 8,248, viz. of groundnut wine, debt 26,063, 68 yards, 187 drums, debt 2,244 and 1,000 guinea bags, debt 4,000. In his written statement, the defendant contended that only 78 drums and 63 guinea bags remained with him, and that the claim of interest on debt 20,030 being untenable in law, he is not liable to pay. He did not specifically deny the other claims. The following three issues were framed. 1. How many drums and guinea bags were left with the defendant on 2nd June 1961? 2. Are the plaintiff entitled to interest as claimed in paragraph 13 of the plaint? 3. What is the total amount due to the plaintiff from the defendant? At the time of the hearing of the suit, the defendant and his learned advocate produce and show some receipt to the learned government advocate for the plaintiff at the bar and the latter accepted the statement of the defendant in his written statement that only 78 drams and 63 guinea bags remained with him as correct. The parties worked out the values at J4 for each guinea bag and J12 for each dram and got the figure J1188, which the landed government advocate agreed to accept in place of the original claims in the plaintiff's J4000 for 1000 bags and J2244 for 187 drams, total J6244. The first issue is accordingly answered in favor of the defendant. Both the parties agreed that the amount now due and to be decreed, excluding the interest, J4950 is J47,251.98 bia. They declined to adduce oral or documentary evidence. The real contest is over the claim of interest on J20,030 bia, amounting to J4,950. Arguments were had on second issue by consent. There is no dispute that there was no agreement to pay interest. In paragraph 12 of the plaint, it was alleged that repeated demands had been made for payment, but to no avail, and finally a legal notice, day 20 November 1964, from the Office of the Attorney General was sent, but it met the same fate. The defendant admitted the receipt of the notice in paragraph 8 of his written statement. In paragraph 13 of the plaint, the plaintiff stated that since the groundnut had been sold to the defendant, they had the right to claim interest in law on the balance purchase money, J20,030 bia. The defendant denied liability. The landed government advocate relied upon Section 61 of the Sale of Goods Act, under which a seller can recover interest in any case where by law interest may be recoverable. Subsection 2A give the court discretion to fix the rate of interest in the absence of contract for payment of interest from the date of the tender of the goods or from the date on which the price was payable. The landed government advocate did not say by which law interest is recoverable. This point must be established first. According to the plaint, the claim of interest is for the period between the date of last part payment and the date of suit. The crucial question, therefore, is whether the court has authority to allow interest for the period prior to the institution of the suit. In Bangay Nagpur Railway Company Limited vs. Ratanji Ranji 1, the Privy Council said, the solution of this question depends not upon the Civil Procedure Code, but upon substantive law. Now, interest for the period prior to the date of the suit may be awarded if there is an agreement for the payment of interest at the fixed rate, or it is payable by the uses of trade having the force of law, or under the provision of any substantive law entitling the plaintiff to recover interest, as for instance, under Section 80 of the Negotiable Instruments Act 1881. In the present case, there is neither agreement nor evidence of uses of trade to justify the award of interest. As a matter of fact, mercantile usage to pay interest in a case of this nature was not specifically pleaded. Section 34 of the Civil Procedure Code relates mainly to the award of interest. In the discretion of the code from the date of suit to the date of decree. Section 73 of the Contract Act is not applicable inasmuch as it relates only to compensation for any loss or damage caused for breach of contract. In my opinion, the only substantive law that now remains to be considered is the Interest Act. Under Section 1 of the Act, the Code has discretion to award interest upon all debts or sums certain payable to the creditor at a certain time, or if payable otherwise than from the time when demand of payment shall have been made in writing, so as such demand shall give notice to the debtor that interest will be claimed from the date of such demand until the time of payment. The learned judge in Kalyan Sahai vs. Pham Lakshmi Narayan Shambhule 2, in interpreting the law, more clearly said that, under the provisions of the Interest Act, the Code might allow interest where time was fixed for payment, or where no time was fixed from the day on which the demand of payment was made in writing, giving notice to the debtor that interest would be claimed. In the instant case, no time was fixed for payment of the debt, nor is there anything to show that a claim for payment of interest was made in the legal notice. Paragraph 10 of the plan merely said that after making two-part payments on two different days, there remained a sum of debt 20,000 30 to be paid. It does not say, 1. Though interest is claimed on this very sum, in the last cited authority, it was held it is necessary for payment of interest under Section 61, State of Goods Act, that the date of the payment must be certain. In Subramania Iyer vs. Subramania Iyer and others 3, it was also held that interest is not claimable where there is no agreement to pay interest and no demand in writing, so as to bring the case within the provisions of the Interest Act. In the circumstances, I refuse to accept the argument of the learned government advocate that interest is payable under Section 61 of the State of Goods Act. It has no substance. The claim for interest from the date of last part payment to date of suit is untenable in law. However, as pointed out above, the Code has discretion to award interest in a suitable case under Section 34 of the Code of Civil Procedure on the amount from the date of suit 4 December 1964 to the date of the decree, that is, interest pendentility. The discretion must, of course, be exercised on sound principles. In paragraph 9 of the plan, it is alleged that the contract was broken by mutual consent on 2nd July 1961, and in paragraph 10, it is alleged the last part payment was made on 5th February 1962 by the defendant. Since then, no payment has been made in spite of repeated demands and a legal notice dated 20 November 1964. The suit was instituted on 4 December 1964 and summons was served on the defendant in February 1965, but he took 3 months to file his written statement. The hearing of the suit was adjourned 3 times at the instance of his learned advocate on the ground that no content could be made of each other. In these circumstances, I think it is equitable to award interest under Section 34 of the Code of Civil Procedure. The second issue is thus answered in the affirmative. In the result, there shall be a decree in favor of the plaintiff for payment of debt 47,251.98 bia by the defendant together with interest calculated on debt 20,030 bia at 9% per annum from date of suit 4th December 1964 to the date of the decree and cost on contested scale on debt 47,251.98 bia.